Real Property Taxation and Special Education Fund Tax Seconds of Finance v. Eilard and Cipriano Cavalluna. Facts: Cipriano P. Cavalluna, Jr., was the Regional Director of Regional Office No. 6 of the DOF. He co-owns with his wife certain properties in Jhojo, Iloilo City. Private respondent failed to pay the land taxes on lot number 12 and lot number 14 for the years 1986 to 1992. For the years 1991 to 1992, taxes were also unpaid on lot No. 941D2, on the residential house, and on lot No. 941D1. A breakdown of the computation of the delinquent taxes showed that more than 24% of the delinquent taxes were charged and collected from private respondent by way of penalties. Private respondent paid his land taxes and the receipts were issued to him by the city treasurer's office with the notation paid under protest. Soon, Cavalluna retired. He then filed a formal protest with the city treasurer of Iloilo wherein he contends that the computation was erroneous since the rate of penalty exceed 24% in contravention of section 66 of PD number 464, otherwise known as the Real Property Tax Code. The Assistant City Treasurer Rizalina Tullio turned down the protest, citing Sector 4 of Joint Assessment Regulations No. 1-85 and Local Treasury Regulations No. 2-85 of the DOF. Despite his labors to exhaust all administrative remedies, the denial of his protest and his MR compelled private respondent to file a petition for declaratory relief with damages assailing Joint Assessment Regulations No. 1-85 and Local Treasury Regulations No. 2-85 which, according to him, flouted section 66 of PD number 464 which fixed the maximum penalty for delinquency in the payment of real estate taxes at 24% of the delinquent tax. The respondent judge declared as null and void the said regulations and ruled that the total penalty must not exceed 24% of the delinquent tax. Issue 1. The Ministry of Finance could legally promulgate regulations prescribing a rate of penalty on delinquent taxes other than that provided for under PD 464, also known as the Real Property Tax Code. Ratio: petitioner's standpoint is devoid of basis in law or in logic. The subject regulations must be struck down for being repugnant to section 66 of P. D number 464 or the Real Property Tax Code, which is the law prevailing at the time material to this case. Note that under section 66 of PD No. 464, the maximum penalty for delinquency in the payment of real property tax shall in no case exceed 24% of the delinquent tax. Upon the other hand, Section 4 of the challenged Joint Assessment Regulations No. 1-85 and Local Treasury Regulations No. 2-85 issued by Respondent Secretary of Finance provides that the penalty of 2% per month of delinquency or 24% per annum as the case may be, shall continue to be imposed on the unpaid tax from the time the delinquency was incurred up to the time that the delinquency is paid for in full, as adeptly observed by the trial court. The penalty imposed under the assailed regulations has no limit inasmuch as the 24% penalty per annum shall be continuously imposed on the unpaid tax until it is paid for in full, unlike that imposed under Section 66 of the Real Property Tax Code where the total penalty is limited only to 24% of the delinquent tax. That such is the effect of an application of the regulations under review is not disclaimed by the petitioner anywhere in his pleadings. Petitioner, however, attempts to justify the issued regulations' departure from the Real Property Tax Code. Said regulations, petitioner says, are sanctioned by EO 73 and its implementing guidelines, Joint Local Assessment/Treasury Regulations No. 2-86. Joint Local Assessment/Treasury Regulations No. 2-86. The Secretary of Finance avers in his petition that the last paragraph of Section 1, Joint Local Assessment/Treasury Regulations No. 2-86, explicitly provides for a 2% per month penalty without any limitation as to the maximum amount thereof, which is entirely consistent with the then existing regulations, the now challenged Joint Assessment Regulations No. 1-85 and Local Treasury Regulations No. 285. Petitioner further asserts that inasmuch as Joint Local Assessment/Treasury Regulations No. 2-86, which echoes the disputed regulations, was issued to implement EO No. 73, private respondent's recourse is to file a case questioning the validity of Joint Local Assessment/Treasury Regulations No. 2-86 in the same way that he has assailed Joint Assessment Regulations No. 1-85 and Local Treasury Regulations No. 2-85. Petitioner's reasoning is, to our mind, but a futile attempt to muddle the facts of the case and the issues involved. Recall that the present controversy cropped up when Cabelluna protested the payment of penalties on his delinquent taxes for being in excess of the 24% cap provided in PD number 464 or the Real Property Tax Code. In response to his letter of protest, the Assistant Treasurer of Iloilo City justified the assessment by citing Sector 4 of Joint Assessment Regulations No. 1-85 and Local Treasury Regulations No. 285 issued by Petitioner Minister of Finance. This has led to the filing of the present case by Cabelluna to question the validity of the said regulations. It is the validity of said regulations, not Joint Local Assessment/Treasury Regulations No. 2-86, that is sought to be resolved herein, and petitioner should not depart from the issue on hand. The court harbors doubts on the veracity of petitioner's contention that the regulations at issue are sanctioned by EO No. 73. The underlying principle behind EO No. 73, as gleaned from the whereas clauses and section 1 thereof as quoted above, is to advance the date of effectivity of the application of the real property tax values of 1984 from January 1, 1988, the original date it was intended by EO No. 1019 to take effect for purposes stated therein, to January 1, 1987. EO No. 73 did not, in any way, alter the structure of the real property tax assessments as provided for in PD No. 464 or the Real Property Tax Code. Neither is this court easily dissuaded by the submission of the Secretary of Finance that EO No. 73, which provides in Section 2 thereof that, the Minister of Finance shall promulgate the necessary rules and regulations to implement this executive order, has the effect of according petitioner the blanket authority to tinker with the rates of penalty on delinquency taxes as provided for in PD No. 464. The General Law on Real Property Taxation. The court takes notice that EO No. 73 did not touch at all on the topic of amendment of rates of delinquent taxes or the amendment of rates of penalty on delinquent taxes. EO No. 73, particularly in Section 2 thereof, has merely designated the Minister of Finance to promulgate the rules and regulations towards the implementation of EO No. 73, particularly on the application of the real property values as of December 31, 1984, which is the general purpose for enacting said executive order. In our mind, what is patent from Section 3 of EO No. 73 is the repeal of EO No. 1019, not Section 66 of PD No. 464. Neither did EO No. 1019 directly or indirectly vest upon the Department of Finance the right to fiddle with the rates of penalty to be assessed on delinquency taxes as contained in the Real Property Tax Code. Even assuming that EO No. 1019 had vested the then Ministry of Finance with the authority to impose new rates of penalty on delinquency taxes, as petitioner would have us believe, such authority would have been automatically stripped off from it upon the express repeal of EO No. 1019 by EO No. 73 on the 25th of November 1986. Despite the promulgation of EO 73, PD 464 in general and Section 66 in particular, remained to be good law. To accept petitioner's premise that EO 73 had accorded the Ministry of Finance the authority to alter, increase, or modify the tax structure would be tantamount to saying that EO 73 has repealed or amended PD 464. Repeal of laws should be made clear and expressed. Repeals by implication are not favored as laws are presumed to be passed with deliberation and full knowledge of all laws existing on the subject. Such repeals are not favored, for a law cannot be deemed repealed unless it is clearly manifest that the legislature so intended it. The failure to add a specific repealing clause indicates that the intent was not to repeal any existing law, unless an irreconcilable inconsistency and repugnancy exist in the terms of the new and old laws. We find, as the trial court has found, no such inconsistency or repugnancy between EO 73 and Section 66 of PD 464. Jurisprudence thrives to the effect that it is only Republic Act No. 7160 or the Local Government Code of 1991, which repealed the Real Property Tax Code or PD No. 464. Assuming argumenti that EO No. 73 has authorized the petitioner to issue the objected regulations, such conferment of powers is void for being repugnant to the well-encrusted doctrine in political law that the power of taxation is generally vested with the legislature. Yes, President Corazon Aquino, at that time, was exercising both executive and legislative powers. But, the power delegated to the executive branch, in this case the Ministry of Finance, to lay down implementing rules must, nevertheless, be germane to the general law it seeks to apply. The implementing rules cannot add to or detract from the provisions of the law it is designed to implement. Administrative regulations adopted under legislative authority by a particular department must be in harmony with the provisions of the law they are intended to carry into effect, which in this case is merely to antedate the effectivity of the 1984 real property tax values, inasmuch as this is the raison d'etre of EO No. 73. In a last-ditch effort to salvage the impugned regulations, petitioner pushes on that Joint Local Assessment/Treasury Regulations No. 2-86, or the so-called implementing rules of EO No. 73, is not contrary to Section 66 of PD No. 464 inasmuch as the latter applies merely to simple delinquency in the payment of real property taxes, while the former covers cases wherein there was failure to promptly pay the real property tax due, including the increase in tax due and demandable for the tax year as a result of the application of the 1984 new or revised assessment of the value of the subject property. Such rationalization lacks legal traction. PD No. 464 makes no distinction as to whether it is simple delinquency or other forms thereof. The Real Property Tax Code covers the wide ilk of failure to promptly pay the real property taxes due and demandable for a particular period. Ubelex non distinguit nec nos distinguere debimus. When the law does not distinguish, we must not distinguish. Further, PD No. 464 covers all real property titled to individuals who become delinquents in paying real estate tax. PD No. 464 is a law of general application. On the second assigned error, the fact that private respondent Cabelluna was responsible for the issuance and implementation of Regional Office Memorandum Circular No. 04-89, which implemented Joint Assessment Regulations No. 1-85 and Local Treasury Regulations No. 2-85, does not put him in estoppel from seeking the nullification of said regulations at this point. In the case at bar, however, petitioner is suing as a plain taxpayer, he having already retired as regional director. His official acts as regional director could not have stripped him of his rights as a taxpayer. To be sure, the official acts of petitioner as regional director cannot serve as estoppel for him to pursue the present course of action that he has taken as a taxpayer. In any event, a regulation which is in itself invalid for being contrary to law cannot be validated by any act of endorsement of any official, much less by a subordinate of the official who issued such regulation. Estoppel, certainly, cannot make an invalid regulation valid. At bottom, the law applicable, in the case at bar, for purposes of computation of the real property taxes due from private respondent for the years 1986 to 1991, including the penalties and interests, is still Section 66 of the Real Property Tax Code of 1974 or PD number 464. The penalty that ought to be imposed for delinquency in the payment of real property taxes should, therefore, be that provided for in Section 66 of PD number 464, i.e., 2% on the amount of the delinquent tax for each month of delinquency or fraction thereof, but in no case shall the total penalty exceed 24% of the delinquent tax. Accordingly, the penalties imposed by Respondent's City Treasurer and Assistant City Treasurer of Iloilo City on the property of private respondent are valid only up to 24% of the delinquent taxes. The excess penalties paid by the private respondent should, in view of that, be refunded by the latter. However, from January 1, 1992 onwards, the proper basis for the computation of the real property tax payable, including penalties or interests, if applicable, must be Rep. Act No. 7160, known as the Local Government Code, which took effect on the 1st of January 1992 inasmuch as Section 534 thereof had expressly repealed PD No. 464 or the Real Property Tax Code. Section 5 of Rep. Act No. 7160 provides that rights and obligations existing on the date of effectivity of the new code and arising out of contracts or any source of prestation involving a local government unit shall be governed by the original terms and conditions of the said contracts or the law in force at the time such contracts were vested.